Hi, my name is Delphine Akinshete, a solicitor at Delphine Philip Law Limited. My areas of law are general litigation, which means that I advocate at court. We can also instruct a barrister to attend court for you if you are looking for an advocate. Today I'm going to be talking about child arrangements order. Basically because if I've had 10 telephone calls today, 5 of them have been from people who have said, I'm not able to see my child. And because of the coronavirus, mother or father has decided that I cannot see my child until the end of the coronavirus, which is ridiculous because nobody knows when all of this is going to end. One thing that everyone should understand, especially if they're restricting the other party from seeing their children or child, or they're seeking to see a child, is that the coronavirus should not stop you from seeing your child, because contact is the right of a child, not the right of the parents. So the question always comes, what do I do now? I do not know where to start from. As solicitors, we make an application to the court asking for the court to allow you defined contact for you to see your child. We call it a child arrangement order. Sometimes it might be that you want to prohibit a parent from doing a particular act, like taking your child out of the country, or you're seeking a specific order. We can ask the child, a passport be sent into court, just so that the other party is not able to take your child outside country. If you have any fears like that, please let us know by calling us. So what is a child arrangement order? A child arrangement order is an order that is made by the court to decide where a child should live, or whether a child should spend time with a particular parent. So if you haven't been seeing your child for a particular time, the court will decide whether you should see your child. If we have had 2,000 cases, we have won over 95% of those. Because when it comes to contact, like I said, is not the right of a parent, it's the right of a child. It's very important that a child has both parents in their lives. But the court always looks at whether there are reasons why a particular family member or a particular parent should not have contact with a child, like if the child is suffering harm or the child is going to suffer harm. Sadly, some people fill out these court forms without understanding that when it comes to harm, there are different types of harm. Some people would answer the forms in the negative. So say for instance they're asked, have you ever suffered domestic violence, or has the child suffered domestic violence? Some people will tick the box of no, but then halfway through the case, or when they manage to instruct a solicitor or a barrister, we then find that they have been suffering harm, because domestic violence is defined differently. If you are suffering emotional harm, physical harm, or any kind of psychological harm, that is domestic violence, and that is definitely something that should be raised to the court. And as solicitors, we make sure that that is raised at court and is properly dealt with. Now, there are other options than just going to court. We have what is called the overriding objective, which is basically for parties to save time and money. That's the overriding objective of the courts. So if you're able to discuss with this partner or the ex-partner whether you're divorced or separated, then you should definitely do so. If you're finding that difficult, as solicitors, we don't always have to rush to the courts. We can actually advise you to go see a mediator. Mediation is compulsory, even if you wanted to bring a child arrangements order case to court. So you would still have to mediate. And sometimes we find that as far as both parties are reasonable and are happy to be bound by mediation, it does work. Sometimes we just have to send 1 or 2 letters to the other side for them to understand that they need to allow you see your child. And most times that is effective. But then if none of this works, then sadly we will have to go to litigation. That is where we step in as solicitors. As a solicitor, I advocate at court. I'm quite happy to help you. So please feel free to call us or email us. The number and the email address is left on the screen, but please only contact us during business hours. Mediation is an alternative to litigation, and it costs less. Is where a mediator will see you and your ex-partner or your present partner, and will talk to you and find out what you want to do. That's the only time that one person can act for two people, mediation and other forms of ADR. But as solicitors, we are not allowed to act for two parties, so we can only act for one person. Because if we were to act for two people, there will be a conflict of interest. Not knowing how to fill the court forms or what to say at court can be very detrimental, and that's where we come in. It is possible that your partner alleges that there has been domestic violence and that the court then has to conduct a fact-finding hearing. That is very, very difficult for most people to handle on their own without the help of a solicitor or a barrister. We're talking about your child here, and you only get one shot at getting contact right. So feel free to call us. We'll be quite happy to talk to you about a fact-finding hearing in another video, or about parental responsibilities, having access to your child, prohibitive steps order, specific issue order, different other orders that the courts can make. Feel free to contact us. I hope that this video has been helpful, or at least to some extent informative. Thank you for watching. My name is Delphine Akinshite. I am not your solicitor until you instruct me. I only give guidance on this channel. Please subscribe, like and share, and come back for more informative videos. Bye for now. Bye.